Hello, good morning all. Happy midweek. Okay, hope you have a good breakfast just now. I'm Deborah from Learning and Development Department, and welcome to today's Property Conveyancing Symposium PCS session. So today we are delighted to invite Ms. Jessica from Simon Tech and Partners to give a talk on the topic, Legal Insights on How to Handle a Deceased Person Estate. So now let me pass the mic to Jaslyn from Simon Tech to do a short introduction before we start the session. Jaslyn, please. Over to you.
Okay, thank you, Deborah. Thank you, Deborah and Vincent, for inviting us to do this sharing session. Good morning to everyone. I'm Jaslyn, one of the Business Development Manager in Simon Tech and Partners. And today with me, I have Ms. Jacinta Pillay, who's going to do the presentation, and also my other colleagues, Gary and Janelle. So before we start on the presentation, I would like to give a short brief about our company first. And just to let you know that basically all the informations in the presentation slides are basically general information. So if you want to seek for more details about it, feel free to approach either one of us and we'll be happy to share with you later. So basically our law firm is under Tech Law, which is a worldwide alliance of independent law firms, consists more than 90 countries in the world. So from this tech law, we can help the clients to apply for the multiple wills when they have multiple assets in other countries. And recently, tech law has been top ranked by the Chambers Global in 2020 as the elite law firm network. Simon Tech and Partners was established in 1994, and we do focus on the private client practice. We do have 4 verticals. The first one is immigration, where we can help the clients to apply for the Singapore PR through Global Investor Program, and we are on the ADB panel of it. And the second one, we can also help the clients to apply for the Singapore PR renewal, along with applying for the Singapore citizenship. The second one is real estate and conveyancing, where we can do all transactions such as sale, purchase, redemption, refinance, and even decoupling. Other than that, we also provide another service like leasing and en bloc. We are on the panel of CPF and also on the majority of the banks panel. The third one is family legacy planning, where we can help the clients to make the legal documents such as will, LPA, and AMD. And further from that, we also offer another service like letters of administration and grant of probate. So from this family legacy planning, we offer the clients to do the wealth and legacy screening, which is a non-obligatory consultation with one of our lawyer. So our lawyer will ask them 5 pages detailed questionnaire about family, asset, and structure. And from there, our lawyer will find out whether they have wealth gaps or not. And we will come up with the action plan as well. On the legacy planning, we also offer another service like trust advisory and professional deputies and donee scheme. For the professional deputies and donee scheme, the Singapore government has been launched since 2017, and 2 of our lawyers are actually part of this program. And one of them is actually Ms. Jacinta Pillay. For the last one is family office, where we can do MAS 13X and 13R. So our business development team is based in Paragon office, but we do have another office in Toa Payoh in HDB Hub to take care of the HDB matter and also some of the legacy planning matters as well. We do have 2 desks, Indonesia and North Asia desks. For the Indonesian desk consists of 1 Indonesian lawyer based in Toa Payoh and also Indonesian PTM, and I'm one of the Indonesian PTMs. Also for the Indonesian back staff who helps the lawyer to take care of the Indonesian clients. And for the North Asia desk, most of the lawyers, they can speak in Mandarin. Also for the back staff people, they can help to communicate with the client through email or even WeChat in the native language as well. So without any further ado, I would like to invite Ms. Jacinta to start on the presentation. Thank you.
Thanks, Jaslyn. Good morning, everyone. Thanks for spending this short morning with us. Today, I'll be sharing about legal insights into how to handle a deceased person's estate. Hopefully, the information will be useful and relevant for all of us in the real estate industry, because I guess in the course of your work, you would probably, from time to time encounter situations where clients have passed on or have family members who have passed on and you need to handle their conveyancing. So this presentation is to give you an understanding on why it is important to do planning and how it impacts us if proper planning is not in place. Okay, so this slide is a brief introduction of myself. I've been with Simongtek and Partners since 2007. My portfolio is mainly in real estate, conveyancing, as well as in legacy planning, trust advisory work. Okay, so before I start the presentation proper, here is a quote which I find very relevant. It says here, all deaths are sudden, no matter how gradual the dying may be. It's a reminder to all of us that firstly, brevity of life, right? At some point in time, we will expire. But no matter how you plan, death will always take you by surprise. So it is important for us to plan, right? Now, when we talk about family legacy planning, in our firm, we focus on three very important instruments. So I'll briefly share with you what they are. And the focus today is really on the will. Okay, the aspect that we're focusing on is more on death. So the first document that I'll be talking about is the lasting power of attorney. Second is the advanced medical directive. And the third document is the will. Okay. Now, the LPA, lasting power of attorney, is basically a legal document which allows you to appoint somebody to act on your behalf if you lose mental capacity, right? So, loss of mental capacity is not merely an old age phenomenon, right? So I guess there are a lot of people out there who think that, okay, only the elderly need to be concerned about LPA. It's true, with age, we are concerned with issues like Alzheimer's, dementia, which would result in a person losing mental capacity, right? But we also have incidents to deal with, such as accident leading to coma or stroke affecting a person's mental capacity. Now, this can really hit at any point. So loss of mental capacity is a contingency that we need to take care of. Now, how do we do that? Now, if you have a document called the LPA in place, you would have appointed somebody to act on your behalf as your donee if such a situation arises. So this allows you to plan in advance. Okay, and your donee basically can step into your shoes to manage all your affairs, your personal welfare as well as your financial matters. So your donee has got a lot of powers to handle your affairs, and of course your donee needs to act in your best interest. Now, if a person loses mental capacity and does not have an LPA, so basically everything freezes. No one can randomly take over his affairs, handle his property transactions, withdraw money from his bank account, deal with his personal matters. If they would like to do that, they would need to be a relevant person, that means a next of kin, and they need to apply for a court order. Now, the court application process is a very convoluted and expensive process. Having an LPA ensures that we need not go through the court application process. So it is a very important planning tool that everybody should look into. Okay. Now, the second document is the Advanced Medical Directive, AMD for short. Now, the AMD is a legal document which allows you to state that you do not wish to prolong the process of dying in the event you are unconscious and terminally ill. And basically, 3 doctors have already confirmed that there is no reasonable prospect of recovery. So if an AMD has been signed, it means that the patient has already made this decision in advance. If those conditions are fulfilled, the doctor will basically remove the life-sustaining treatment, whether it's a life support machine or intubation. Now, why do people do an AMD? Imagine a situation where a patient is in that condition, right? Terminally ill, unconscious, and already no prospect of recovery. Now, if there is no AMD sign, the doctors would enter into a conversation with the family members, right? And it'll probably be something that the family members need to decide what course of action to take. Is it to continue with the life support or to remove it? Now, this kind of a decision is a very tough decision to make. So generally, family members will have difficulty, and invariably there will be differences in opinion. So if that arises, it could lead to conflict among family members. And in order to prevent such a situation, some people would like an AMD to be drawn up, because if they have an AMD sign, it means that they have already made that decision in advance, and they have taken a very difficult decision out of the hands of their family members. Now, another reason why people do AMD is for financial reasons. We all know that medical care, healthcare in Singapore is very expensive. Now, if the outcome is there is no prospect of recovery and death is the outcome, then sometimes people may opt to sign the AMD so that they don't drain the resources of the family to keep them alive and with no prospect of recovery. So that's another reason why people do an AMD. So as you can see, it is indeed a legacy planning tool, because it helps to preserve family ties, and it also helps to preserve your financial legacy. Okay. And lastly, the final document that I'll be sharing on, which is basically what we're talking about today, is about the will. Okay, a will is a legal document that allows you to set out your wishes and instructions on how you wish your assets to be distributed the day you are no longer around. Okay, now we know that death is a certainty. It's just a matter of when, right? It's not a matter of if. Now, if we know that death is something that will happen to all of us at some point in time, is it not important for us to plan, right? So the will is that instrument that allows you to state how you would like your assets to be distributed according to your wishes the day you're no longer around. So I'm sure everybody is familiar with what a will is. So today we'll be sharing more about what happens if a person doesn't have a will. Why is it important to have a will, and what are the practical considerations? Okay. Now, usually when a person passes on, the first thing that will come to mind would be things like who can take over the administration of the deceased estate, who can settle his loans and debts if there are any, and who will transfer the assets to the beneficiaries. So basically, someone has to step into the shoes of a deceased person to handle all these matters. So the questions would be as such, who can do that? Okay, now when a person passes away without a will, or where he passes away with a will, you always need to apply for a court order. Okay, the court order is actually the document that empowers the legal personal representative to manage the deceased asset. So the person that steps into the shoes of the estate of the deceased person is his legal personal representative. In both instances, whether the person had a will or did not have a will, you would need to apply for a court order. Okay, so when a deceased person passes on without a will, the court order that we're looking at is called the grant of letters of administration. So I'm sure in the course of your work, you would have come across the term grant of letters of administration, grant of probate. Now, grant of letters of administration is what you apply for if there is no will. Grant of probate is what you apply for if there is a will. So I will introduce you to the Intestate Succession Act. Now, Intestate Succession Act is basically the law that determines how assets are to be distributed when a person passes on without a will. Because if you have no will, you have not set out your wishes on how you want your things to be settled. Who are the beneficiaries? So the law will determine that distribution for you. Okay. Now, the law in question is the Intestate Succession Act. And there is a distinction in whether a person is single or married, and that will determine how the distribution works. Now, if a deceased is single, that means he's unmarried, he's widowed or divorced. This is the chart that will determine how the distribution is to be made. Firstly, are there children? If the deceased had children, then the children will inherit equally. Now, a single person can have children because he could be a widowed person or divorced. Now, second in line would be parents. If no children, then the parents will stand to inherit equally. If no parents, then siblings, and then grandparents, and so on. So that's basically how the Intestate Succession Act distributes a deceased person who's single, the assets of a deceased person who is single. Now, in this chart, we look at how assets are to be distributed if the deceased is married. Okay. Now, if the deceased is married, you would firstly consider whether there are children in the marriage. If there are children, then the spouse will get 50% and the children will get 50% equally. Now, if there are no children, then the spouse gets 50% and the parents will inherit 50%. If there are no children, no parents, then the spouse inherits 100%. So that's basically how the law will determine the distribution if the deceased is married. Now, why am I showing you the Intestate Succession Act? The reason is when it comes to applying for grant of letters of administration, who are the legal personal representatives entitled to apply? That would be the beneficiaries under the ISA. So if you are not one of the beneficiaries in that order, you will not be entitled to apply for the Intestate Succession Act. If you do need to apply, then you have to convince the court why you can apply. And it is, as you can see, restrictive, right? Imagine you have children. If you have, say, 5 children, of the 5, maybe you are particularly close to one child and you think that is the child that can manage everything for you, the most reliable. Now, if you do not have a will, under the Intestate Succession Act, all 5 have equal rights to apply. Then the question is, who will apply? They need to come to an agreement among themselves and step up to make that application, right? So that is one consideration. Now, the process for applying for grant of letters of administration is less straightforward than applying for grant of probate, right? Because as you can see under the Intestate Succession Act, it is all about relationship. Now, how do you prove that you are the children of the deceased? How do you prove that you're the spouse? How do you prove that the parents have passed on? All these things have to be by way of documentary evidence. So imagine a situation where a person passed away. Maybe let's go back to this chart. Yeah? So maybe the person passed away, he's married, okay, and he's got no children. So in order to apply for the grant of letters of administration, his parents will be entitled, his spouse will be entitled because they are the beneficiaries. So in that sense, they are entitled to apply for the grant. Now, if say the spouse steps up because the parents are deceased already, then the question is, how do you prove that the parents are deceased? You need to have the death certificate, right? To show that. Now, based on our experience, sometimes obtaining these documents, especially if things like death certificates of parents or even marriage certificates of parents, it could have happened many years ago. And to obtain these documents may be a very challenging process. Although, legally speaking, it's very straightforward. Okay, who are entitled, who can apply. But when it comes to the practical application, what we often encounter is clients have difficulty producing these documents, right? And another complication that could arise is if we deal with foreign clients. So I'm sure in the course of your work, you would have clients who are foreigners, right? So foreigners investing in Singapore, maybe they buy real estate, they open bank accounts and they have certain investments here. Now, if they pass on, they would still need to, their family would still need to apply for grant of letters of administration before they can deal with those assets. Now, when it comes to foreigners applying for grant of letters of administration, it is usually more complicated because they will have difficulty producing those evidence to us. For example, death certificates, marriage certificates, birth certificates. In Singapore, we do have the relevant registries that we can extract those from, but in other jurisdictions, it may not be so straightforward. Now, the other problem that we encounter is that when we deal with foreign clients, those documents are in a foreign language. So when it's in a foreign language, we need to get translations done. When translations are done, we need to support that with additional affidavits like the translator's affidavits. So a lot more things need to be submitted to the court in order to apply for the grant of letters of administration. And then also another complication that could arise is when you deal with a foreigner who has assets in Singapore, we are not looking at the Intestate Succession Act. The Intestate Succession Act applies to those who are domiciled in Singapore. So if let's say you're dealing with a foreigner, say coming from China, the laws in China will apply because that the domicile of the deceased is China. So China laws will apply in terms of how the assets are to be distributed upon the demise of this person. So on that basis, another very important document that is required is called the foreign law affidavit. Okay, so the lawyer from the jurisdiction where the deceased is domiciled would need to produce a foreign law affidavit to present to the Singapore court to explain under, say, in this case, China law, who is entitled to be the legal personal representative to apply for the grant, and under the law, who are the entitled beneficiaries. Now, in the foreign law affidavit, they would also need to produce the legislation or the statutes or the law that they're relying upon. So this document is very important and needs to be submitted to the court because the Singapore court would have no idea how the foreign laws work in terms of distribution. So they rely on the foreign law affidavit. And what we have encountered is sometimes obtaining this foreign law affidavit is a very challenging process. Okay, so as you can see, obtaining the grant of letters of administration is less straightforward because wishes are not stated, the appointed persons are not chosen, so you're relying on the law. And when this happens, there are a lot of additional things that need to be submitted. Now, sometimes in the case of a foreigner investing in Singapore, it could only be a very small investment in the entire scheme of things. Maybe this person has got assets in many jurisdictions and Singapore is one of the jurisdiction. So maybe in Singapore, he has one life policy or he has one property or a bank account. Now, regardless of how extensive or small the investments are in Singapore, the grant of letters of administration is still required. So sometimes we get foreign clients lamenting that, why are you taking so long to obtain the grant? Why are you asking me for so many things? Why is it so complicated when my deceased father only had one bank account? What, you know, it's just one bank account. So why is the whole process so complicated? Now, the process is the same regardless of how much assets the deceased has. So that is why it is important to plan. Okay, so this is basically to share with you what happens when a deceased passes on without a will. Okay, so now we move on to what happens when the person who has passed on has a will. So like I mentioned earlier, when the person has a will, you also need a court order, and the court order is called the grant of probate. Okay, so in the grant of, to apply for the grant of probate, the process is less complicated because in your will, you would have already named your beneficiaries and you would have determined how you want your assets to be distributed. So we do not need to look at the Intestate Succession Act. Secondly, very importantly, you would have appointed the executor. You would have named the executor. And on that basis, again, we don't need to rely on the law and people don't have to come to an agreement to step up because you have already made that decision. So basically, the executor's job is to take the will, seek legal advice, apply for the grant of probate. Okay, so the procedure for application for the grant of probate is more streamlined, less complicated, and invariably it will be a shorter process. Now, we do also encounter a lot of situations where clients say that, okay, I'm familiar with what the Intestate Succession Act says. I know how the distribution under the law works, and I'm perfectly happy with that. So if I'm happy with the distribution under the law, why should I, incur legal expenses to engage a lawyer to draft the will? Because the will is going to say the same thing. When I die, 50% goes to my spouse, 50% goes to my children in equal shares. So on that basis, I don't need a will. Now, I hope that after explaining to you the administrative differences between applying for a grant of probate versus a grant of letters of administration, you would be able to appreciate that there is really a lot of difference between having a will and not having a will. And even if your distribution aligns with the Intestate Succession Act, it is still very important to have a will drawn up, because then your family can apply for probate and not letters of administration. Now, if the process is less complicated, it will translate obviously to lower legal fees, and it will also allow you to determine exactly how you want your assets to be distributed. You get to decide. Okay. Now, another very important thing I want to highlight is having a will allows you to create a testamentary trust. Okay. So a testamentary trust is basically a trust that comes into effect upon demise through the operation of the will. The terms are in the will. So I'll give you an example. Imagine you have vulnerable beneficiaries. Maybe you have children who have special needs. You know, they cannot take care of themselves. They have certain medical conditions. Or even if you have beneficiaries who are not good with money, you know, maybe they are very spendthrift beneficiaries, or you have vulnerable beneficiaries in the form of elderly beneficiaries. Maybe you want to provide for your elderly parents. Now, if they are elderly, they're vulnerable because, you know, at some point, if they lose mental capacity, whatever that they own, you know, people could try to take advantage of them. So in a sense, they're vulnerable, right? So if you have beneficiaries who are like of this nature, this category, you want to provide for them, right? But if you were to give them a lump sum at one time, it may not be to their advantage because they cannot manage it efficiently. So you would need to then create a trust where a trustee helps you to disburse these funds to your beneficiaries. So we take the example of elderly parents, okay? So if they're elderly parents, you want to provide for them. But if something were to happen to you and you give them a large sum of money, they may not have the financial acumen to manage it, and it may cause them to be vulnerable, right? People may take advantage of them, and then it will not be to their benefit. Now, how do you provide for them? If you have a trustee, you can, through the trust instructions, say, I want you to provide a monthly allowance for my parents in their lifetime. So you can specify that. Now, the will allows you to do that through a testamentary trust. So upon demise, you can say, I set aside X amount of dollars I want to give to my parents, but my trustees will step in and take over. And every month they will disburse this amount until my parents are no longer around. Now, that's an example of a testamentary trust. Or if you have children who are minors, okay, so obviously they cannot manage because they have no legal capacity until they are minimum 21 years old. Now, if something were to happen to you and you want to provide for your children, who is going to safeguard their assets for them until they are of legal age? Again, that comes through the testamentary trust. So that's something that you can provide for under your will. You can even stagger the payouts to your children. Maybe you can say that at 21, they get a certain tranche, at 30, they get another tranche of money, you know, or you can say that they get a yearly amount. All these are things which you can craft in your will, and that's a testamentary trust. Now, if you do not have a will, then you purely go according to the Intestate Succession Act. You would have forgone that opportunity, right, to make a testamentary trust. Now, another very important thing to highlight is guardianship. Now, for those of you who have young children, in the event both parents are deceased, maybe due to an accident, something happens, both parents are deceased, somebody needs to be the legal guardian of the children. Now, having a will allows parents to appoint a legal guardian, right? So you, as a parent, would be in the best position to decide who should take care of your children, who should they live with, right? Now, if you do not have a will, again, you would have forgone that opportunity to appoint a legal guardian, and you would not have made that decision, right? So the court makes that decision for you. So it is therefore important for us to appreciate that the will allows us to do these things, and the best people to make those decisions is really yourself, right? So if you are a parent, you would want to be the one deciding who takes care of your children, right? Who's going to manage your estate, who's going to take over and apply for probate and all that. So that is something that having a will allows you to do, and without a will, you're not able to do that. So quite apart from the distribution, you can see that having a will has got a lot of other administrative advantages. Okay. So now let's talk a little bit about what happens when a person who who owns property passes on. Okay, so I'm sure in the course of your work, you would have dealt with situations where either, you know, the owner has passed on and you're selling the property on behalf of the estate, or in a case where, you know, you are acting for the client and then in the course of the transaction, somebody, the seller or buyer passes away. So what do you do? Now, it is important for us to appreciate that there is a difference between grant of probate and grant of letters of administration. When do you ask for probate? When do you ask for letters of admin? So obviously, if the person passes on with a will, right, then you'll be asking for the grant of probate. If the deceased passed on without a will, then you would want to see the letters of administration. If the death happens before the property transaction, then these are things that you'll be asking for, right? You want to know, did he pass on with a will and things like that. If it happens during the property transaction, we also need to understand, you know, how many owners, what is the manner of ownership. So there's a difference. So I'll take you through the process, right? Firstly, joint tenancy. Now, if a property is owned by just one person, okay, and he passes on, then obviously we don't look at joint tenancy versus tenancy in common. We go straight into whether he has a will or he has no will. Now, one thing you need to understand is if a person has a will, the executor is already named in the will. So that person is the legal personal representative of the deceased. So you can safely liaise with the executor in terms of paperwork, giving of instructions and things like that, because he has already been appointed under the will and according to the intentions and the instructions of the deceased. So the executor's power is derived from the will. Now, ultimately, the executor needs to apply for the court order, which is a grant of probate, which will validate his actions. Okay. Now, if a person passes on without a will, the legal personal representative is the administrator. Now, the administrator's powers are derived from the court order. So until such time the grant of letters of administration is issued by the court, you would not be sure who you are actually dealing with, who has the legal capacity to take over. So if a case where the owner is a single owner, he's passed on, right? And he has a will, and you are instructed to sell the property or to handle the transaction, you can deal with the executor. Okay, but of course the executor needs to take the next step and apply for the probate. And before the whole transaction is completed, we need to have the grant of probate. Now, if you deal with a case where there is no will and there's an administrator to be appointed, then that's the point where you need to stop and ask, where is the letters of administration? If they have not obtained the letters of administration, it would not be sufficient for us to say, oh, you're the son, you're the daughter, you're the wife, I can deal with you, because you never know whether they will eventually obtain the grant, right? So in order to be sure, you need to see the grant of letters of administration to know who is the administrator, so that you are dealing with the right party, because the power of the administrator is derived from the order. Now, in the case of properties owned by two or more owners, then we need to understand the manner of ownership. Now, if it's a joint tenancy situation, joint tenancy operates by way of right of survivorship. So if there are two owners, A and B, and they own the property under joint tenancy, if A dies, everything goes to B automatically, right? Because there is right of survivorship. So if you're dealing with a transaction where it is a joint tenancy, one owner passes on, you don't need the probate, you don't need the letters of administration, because the survivor has the right to take over. So in this case, they need to file a notice of death, and the surviving owner can take over, and you can sell the property just on the instructions of the surviving owner. So that is right of survivorship under joint tenancy. But in the event both are deceased, you will still need a will, right? Now, tenancy in common is another manner of ownership, which I think you're familiar with as well. Tenancy in common is where you have distinct shares in the property. So example, A and B own the property as tenants in common in equal shares. That means each person has 50%. Now, if each person has 50% share under tenancy in common, there is no concept of right of survivorship. Okay, so under those circumstances, you need to go through the process. Okay, did the deceased have a will or not? If he has a will, then show me the grant of probate, the executor can take over and things like that. If the deceased did not have a will, then you would be asking for the letters of administration. So in a tenancy in common situation, you need to understand a little bit more about the situation before you can act. You cannot act just on the instructions of the surviving owner. Okay. Now, another point to note is under the Conveyancing and Law of Property Act at Section 35, no sale or mortgage of land belonging to the estate of a deceased person shall be made by the legal personal representative of that person after the expiration of 6 years from his death, unless there is a sanction of court or unless there's power to sell under the terms of the will. So just purely asking for the grant of letters of administration or asking for the grant of probate is not sufficient. We need to firstly understand when did the deceased pass away. If the deceased passed away more than 6 years ago and he did not have a will, having the grant of letters of administration is not sufficient. They still need to get the sanction of court to sell the property. Now, if the deceased passed away within 6 years, then it's okay, you don't need a court order. So we've encountered situations where for some reason the estate holds on to the property for a long time, and then after a number of years they say, okay, now we want to sell it. Then they will engage estate agents, and then they will produce a grant of letters of admin, and they want to sell the property. Now, if the death occurred more than 6 years ago, then you do need to get another court order, which is a court sanction to sell the property under Section 35(2). And that process must be completed before they can complete the sale transaction. Now, in the other situation where the person passed away with a will, okay, now just because he passed away with a will, there's a grant of probate, executor says, oh, can you sell the property? Is it sufficient for us to just take that grant of probate and then act on the instructions of the executor and sell the property? It is not sufficient, because in some instances, the will may specify that the executor is not to sell the property until a certain time, right? So if the executor does not have the power to sell, then he cannot sell. But you would not know until you know the contents of the will, right? Because there are some cases where the testator may say that, okay, I give my property to my children, but they cannot sell it for the next 10 years, okay, or as long as my wife is alive. And only after she passed on, they can sell the property and distribute the proceeds. Now, if there's such terms and conditions in the will, and the executor goes ahead to sell the property, then it's wrong. So if you are acting for someone who says, I'm the executor, this is a grant of probate, I want to sell the property, it is important for you to ensure that the terms of the will permits the executor to sell. So maybe in such circumstances, they may not be comfortable to review the contents of the will to the parties. So you may want to get lawyers involved. So between lawyers, we can then, get confirmation that the executor has power to sell so that everything runs smoothly. Okay, so that's just some information. So now I'll just share with you 2 case studies. Now in these case studies, it talks about the importance of getting a will drawn up and how sometimes a simple will may not necessarily fulfill everybody's circumstances. So in the first example, there was this inquiry that we received some years back. The background was as such. The deceased were the parents, okay, father and mother. Father and mother had 5 children. Now the parents had a lot of real estate. So their assets comprised largely real estate, and the properties were mainly under joint tenancy. So I shared with you earlier what joint tenancy means, right? Right of survivorship. So if one goes, survivor takes all. So the majority of the assets were real estate under joint tenancy between father and mother. They also ran businesses. Okay, they ran many businesses in the properties that they owned. Now, very long time ago, I think in the 1990s, the father and mother did a simple will each. Okay, father's will said if he goes, everything goes to his wife. The mother's will said if she dies, everything goes to her husband. So that's basically what the will said. Now, the mother ended up having a stroke in, I think it was like year 2000 or something. The mother had a massive stroke, and the doctors basically said that she didn't have a prospect of recovery. Okay, so in fact, death was imminent. That was the prognosis. So when that happened, the father decided that it was time for him to review his will instructions. So if his wife didn't survive him, he was going to distribute his assets to his 5 children. Now, his intention was not to distribute it equally, but he was going to allocate different properties to different children. The reason being, they were running businesses. Each child was running a business out of different premises, okay, helping the parents in different areas of the business. So the father wanted to distribute the assets to the 5 children, not in an equal manner, but according to allocation. Now, the mother somehow survived. I think for a good 10 years, she survived. And but she was in she was bedridden, right? So she was not in the position to amend her will or anything like that. Now, the irony is the father died before the mom. So the father passed away, and then 2 months later, the mother passed away. So that is the background. Now, one of the sons came to see us, and he presented 2 wills. He presented his father's will, which is what I shared with you earlier. It was allocation to different children in different manner. And then he produced his mother's will, which was a simple will that said if she goes, everything goes to the husband. Now, I also shared with you that the bulk of their assets comprise real estate under joint tenancy. So joint tenancy means if the father goes, everything goes to the wife, to the mom, because of right of survivorship. So the mother ended up being the owner of most of the assets. Now, upon her demise, her will says everything goes to the spouse. So the son's request to probate all the assets according to the father's will was not possible because the father died before the mother, and everything basically went to the mom, right? So her will is the one that has to be probated, and the distribution will follow her will. Now, her will says everything goes to the husband. Husband is deceased. How will the distribution take place? So let's go back to the Intestate Succession Act. Yeah. So in this case, the wife was a widow, right? So she's widowed, she's single. Under the Intestate Succession Act, it goes to the 5 children in equal shares. So that's basically how the distribution will take place since the husband has already passed away, and her will did not provide for how the assets are to be distributed if he goes. So the law will take care of it, and the 5 children will inherit in equal shares. Now, the question is, why is that a problem? If everybody gets equal shares, it should not be a problem, right? But in this particular situation, it was a very big issue for them because for more than 10 over years, the children have been running their businesses. They have been entrenched in those properties, expecting to inherit the respective properties because that was their father's wishes and intentions. But by operation of the law, overnight, all the assets became distributed to the 5 of them in equal shares. So they then had this major headache to restructure everything, right? So we know that if you restructure the ownership, you're going to have to incur legal fees, processes involved, and stamp duty. So to them, it was a cumbersome process to deal with, right? To some families, distribute to 5 children in equal shares sounds like a very reasonable thing. But in their specific situation, it was not an ideal manner of distribution. They wanted it to be allocated specific property to a specific child. So they ended up having to restructure because the simple will did not deal with their unique circumstances. Okay, so that's basically to highlight to us that we need to understand firstly, what are the assets that a person has, what are the intricacies of those assets, what are the specific requirements and needs, and then a will has to be structured to meet those requirements because everybody's family situation is different, everybody's demands are different, right? Now, in the second example, I'm going to talk about mortgage risk. Now, when people own property, they usually have a loan, okay, a mortgage over a property. Now, in a lot of circumstances, based on our discussions with people, with clients, they often have the misconception that, okay, example, property owned by husband and wife, okay, as joint tenants, right? Now, if husband goes, everything goes to wife, right of survivorship. So the wife can simply take over the loan and continue paying the mortgage, no issues there. Now, this is not true, because under the terms of the mortgage, if one of the mortgagor dies, it triggers a default. So from the bank's perspective, there is a default and the bank can recall the facility, right? So what happens is the bank can basically say, okay, now that one of the owners passed on, I want the loan to be fully paid. If the surviving owner is not in the capacity to fully redeem the loan, then he or she would have to refinance the facilities. Now, we also know that refinancing, we would need to meet the TDSR. What happens if this situation arises when the surviving owner is elderly, retired, no income? How is he or she going to refinance the loan? Or what if it happens where the surviving owner is a homemaker with no income, not in the position to refinance the loan? Now, if that happens, what would be the outcome would be property has to be sold, and then the proceeds will be used to pay off the bank, and the surviving owner will have the balance proceeds, but she can then, you know, buy another property, but it would result in a lot of disruption, especially if you're dealing with matrimonial property. So this is a mortgage risk that needs to be addressed. Now, if people are not aware of the kind of assets that they have, they don't go into details of planning, then they will not be aware that this is a real risk. And if they're not aware, they cannot address it, right? So I have two examples to share. Now, in one case, we acted for a client who bought a property with his mom. Okay, so he and his mom owned the property. It was an investment property. Now, this client had cancer and he passed on, but he had a will, right? So his will basically said everything goes to the mom. Now, in this particular situation, when the bank found out that the son passed away, they immediately served a default notice and they wanted the facility to be fully paid. Now, before the loan can be paid, the mother needed to sell the property, but she could not sell the property until the grant was obtained, because in this case, it was a tenancy in common situation. So if the grant is not obtained, she cannot sell the property. So meanwhile, the bank was hounding for payment. She needed us to write in to ask the bank to hold their hands, to waive interest if possible until the probate is out so that she can sell the property. So it took some time, right? But the reality is it caused a lot of stress to the mom, because she had to deal with the interest on the loan piling up, and she could not sell until she obtained the grant. So this is a practical reality. Now, in another situation, I dealt with a client who owned a property with the wife, joint tenancy situation. Same thing. There was a loan over the property. Now, husband died. Okay, husband passed away, had a stroke, passed on. The wife took over the property under joint tenancy, but she knew of the mortgage risk. She knew that the bank could ask her to pay off the loan. But in this situation, they actually had proper planning in place. I think the husband had sufficient insurance payout to deal with this mortgage risk. So she had the funds, but she didn't file the notice of death, didn't notify the bank. So she just continued paying the installment. For some reason, I think 2-3 years after the death happened, the bank wrote to her and said, okay, now that we know this, your husband has passed on, we would like the loan to be refinanced or redeemed, because to the bank it was a default. Now, in her particular situation, she did not opt to refinance because it was troublesome to go through the loan application and things like that. But because she already had the funds ready, she did a full redemption of the loan, settled it. So she basically redeemed the mortgage and she transferred the property to her name. So in this case, there was planning. So she was able to react and minimize any exposure in terms of interest rising and things like that. So we need to understand that whatever assets that we have, we need to understand the risk associated with it. So mortgage risk is one of it. Another risk that I can share with you is overseas estate tax risk. Okay, so in certain jurisdiction, there might be taxes that have to be paid on death. So if people have properties in other countries or assets in other countries where there's estate duty, these taxes have to be paid before the assets can be transferred to the beneficiary. So again, that is a risk that the person needs to take care of. So in their overall planning, they can deal with these things to ensure that before assets are passed on to those beneficiaries, they have sufficient money to deal with the taxes. Okay. So in our firm, how do we advise clients, to structure their wills? We basically take a very structured approach where we take clients through a wealth and legacy screening. Okay, we call it WLS for short. Now, we're all familiar with health screening. When you see a doctor for health screening, they make you go through tests, blood tests and things like that to try and find out what is going on inside, so that if there's anything, you can take action, right? So likewise for our wealth, we also need to go through a screening. So what we do is we will go through with our clients a very detailed questionnaire. The questionnaire will basically cover their family background, their concerns, whether they have special needs that we need to be aware of, whether they have beneficiaries that they want to exclude. Now, once we have an understanding of their family, we then need to go through their assets. Okay, that's where we will go through in detail what are the things that they have, whether it's real estate properties, whether the properties are under mortgage or not. Do they have assets overseas? In which country? Do those countries have tax exposure? Do they have joint accounts? Do they run businesses? Now, once we go through the list of assets, we are then able to help them identify certain risks, example, the mortgage risk, right? If they are aware of this risk, they are able to take the necessary action, whether it is to fund it, with insurance proceeds or to have savings parked aside. They are able to address those risks. And finally, we can work out a structure to determine how their assets are to be distributed upon demise. Now, the structure can be a simple one or it can be a complicated one, but it will be customized according to the specific client's needs. So that's basically how we deal with the whole screening process. Now, once instructions are given, confirmed, the lawyer would then be able to proceed with the drafting. And at the second meeting with the client, we should be able to get the will signed. Okay, so that's basically how we approach wealth and legacy screening with our clients in order to help them to structure their legacy documents. So at this point, I hope that I've come to basically almost the end of the presentation. I hope that I have made it convincing enough for you to appreciate that it is important to plan, okay? And having a will is very important. So I hope that, based on what we've done previously, usually at the end of the presentation, the overall consensus would be that it is important to plan, okay? And I almost always get 100% agreement on that. So I'm assuming that everybody in this platform agree as well that it's important to plan. But let me show you some statistics, okay? Based on what we have done, okay, the statistics of our attendees, even though everyone thinks it's important to plan, the reality is only 30% out of 100% actually take action. So how they take action would be to sign up for wealth and legacy screening or to approach us. So what we have noticed is only 30% take action, although everybody thinks it's important. What happens to the 70%? The 70% of the people who attend, who appreciate the importance, they end up not doing anything about it. So the big question is why? Why are they not doing anything about it if it is important? Now, the single biggest reason for that is procrastination, the big P word, which I'm sure we're all familiar with, right? Because when we talk about things like death and legacy, it may seem important, you appreciate it, but when you log off and you go back to your own affairs, it is something that you put at the back burner and you will not address it, right? Because it's not the most pressing thing right now because life goes on, right? And the next time you revisit it is probably at another such presentation, or if something happens within the family and you're triggered. And in some cases, it may be too late, right? So what we have come up with is, we have come up with a QR code, which is basically to help all of us here to take the next step, because we know that procrastination is the biggest deterrent, biggest obstacle for a lot of people. So what we've done is we've created this QR code. If you are interested to take the next step and you are worried about procrastination, then let us help you to get it going, right? So if you scan the QR code, you can basically sign up for a non-obligatory consultation with myself or any of my colleagues who are lawyers, and we would be able to take you through the wealth and legacy screening process and help you propose a structure. So if you sign up, my colleagues will contact you to take the next step, so you can, you know, in a way avoid procrastinating. So if you're interested, please go ahead. You can also reach out to my VD colleagues. The contact numbers are there. Okay.
Okay, thank you, Jacinta. All right, I think I'm constrained, and let's hand back to Jesslyn to
Yeah.
to do the closing, and later she will hand back to Deborah to wrap up the whole webinar.
Okay, thank you.
Okay, thank you, Jacinta. Over to you, Jesslyn.
Okay, thank you, Ms. Jacinta and Gary. So I hope you all find the session very useful, and especially all the information shared by Ms. Jacinta before. And as mentioned before, we offer for the Wealth and Legacy Screening Consultation, the non-obligatory consultation with one of our lawyer. So feel free to scan the QR code on the screen, or you can also click on the link that my colleagues has provided in the group chat by Janelle before. And if you have further questions that you want to get the answers, feel free to approach either me, Gary, or Janelle to help you on that. So thank you very much for joining. So I will hand back to Deborah. Thank you.
All right, so thank you, Miss Janita, for sharing, and thank you all for attending this session. Yeah, so like what Jesslyn has mentioned, if you have any more questions that you need to be addressed, okay, you can contact any one of them, okay, in the slide that you see right now, okay, or you may email to us at learning@orangetea.com, okay, we will collate the question and then send it to Gary or any one of them. Yeah, so that's all for today. Hope you have benefited from this session and have a great week ahead. Thank you and goodbye.